I have sat on this bench long enough to know that arrogance has a distinct sound. It is not always loud. Sometimes it is the quiet, heavy thud of a designer briefcase being dropped onto a defense table. It is the exasperated sigh of a man who believes his mere presence in a courtroom is a tragic waste of his highly valuable time. That was the exact atmosphere Arthur Sterling brought with him when he walked into my courtroom that morning. Arthur Sterling was not just a landlord. He was a real estate titan. He controlled dozens of commercial and residential blocks across the city. He wore a bespoke Navy suit that likely cost more than most people earn in an entire year, and he carried himself with the terrifying confidence of a man who had spent his entire life writing checks to make his problems disappear. He looked at my bailiff, my clerk, and the courtroom itself, not as instruments of justice, but as minor, irritating obstacles. On the other side of the room stood an entirely different kind of man. His name was Elias Thorne. He was 71 years old, a retired schoolteacher, and a widower. He was the kind of man who had lived in the exact same rent-controlled apartment for over 3 decades, quietly paying his dues and bothering no one. Elias wore a faded but impeccably clean tweed jacket. He held his thin file of evidence close to his chest, his hands trembling just slightly, not from fear, but from the deep, exhausting ache of a man fighting to keep the only sanctuary he had left. I pay attention to these contrasts. Effort matters. Dignity matters. The dispute itself seemed, on paper, like a standard civil matter. A landlord-tenant conflict involving damaged property, claims of harassment, and a forced eviction. But paperwork is sterile. Paperwork cannot capture the sheer cruelty of a man who decides to freeze a 7-year-old out of his home in the dead of winter simply because he wanted to flip the building for a higher profit margin. I asked Mr. Thorne to begin at the beginning. He cleared his throat and explained that he had never missed a single rent payment in 32 years. But when Sterling Global Holdings bought his building 6 months ago, the quiet harassment started immediately. Maintenance requests were ignored. The heating was mysteriously shut off for weeks during a brutal January freeze. Elias was told it was a system failure, yet the vacant units being renovated on the floor above had perfect climate control. But the true violation happened just 2 weeks prior. Elias explained that he had returned home from a hospital appointment to find his front door completely removed from its hinges. His belongings, books, family photographs, his late wife's keepsakes had been haphazardly tossed into the hallway by Sterling's private contractors. I turned my gaze to Arthur Sterling. I asked him a very simple, direct question. Did you order the removal of this man's front door without a legal eviction notice? Sterling didn't even blink. He leaned back in his chair, crossed one leg over the other, and smirked. Your Honor, he said, his voice dripping with absolute condescension, it's my building. I make the rules here. The courtroom fell dead silent. He actually believed that holding the deed to a property made him the absolute monarch of the human beings living inside it. He thought his wealth was a shield that the law could not penetrate. He was about to learn a very expensive lesson. I allowed the silence to hang in the room for a long moment. In my courtroom, silence is a deliberate tool. It gives a foolish statement the exact amount of space it needs to echo, allowing the speaker and everyone else to fully absorb the weight of their own arrogance. Beside Mr. Sterling, his legal counsel visibly winced. He was a high-priced, sharply dressed litigator, the kind of lawyer accustomed to settling things quietly in corporate boardrooms. He closed his eyes briefly, understanding what his client did not, that holding a piece of paper granting you property rights does not grant you sovereignty over the law. You make the rules? I repeated, keeping my voice dangerously low. Mr. Sterling, you might want to look at the seal behind my desk before you finish that thought. But we will address your catastrophic misunderstanding of authority shortly. I turned my attention back to the plaintiff. Please continue, Mr. Thorne. You found your door removed. What did you do next? Elias's hands steadied as he opened his folder. I called the property management office, Your Honor, 12 times over 2 days. No one answered. The temperature dropped to 19 degrees that night. I had to sleep in my winter coat, wrapped in 3 blankets, with a heavy armchair pushed against the open doorway because anyone from the street could have walked right in. He handed a stack of photographs to the bailiff. I examined them. They documented a scene of deliberate, calculated humiliation. The heavy wooden door wasn't just removed. The hinges were aggressively stripped, the door frame splintered. Elias's modest belongings were shoved into the public corridor. Among them was a shattered glass display case that had housed his late wife's antique porcelain collection. They told me it was a necessary safety protocol, Elias added quietly. A maintenance crew told me the unit was scheduled for a gut renovation and that I was trespassing. Trespassing, Your Honor? In the home I've paid rent for since 1991. I looked over the bench at Sterling. A safety protocol, Mr. Sterling? Removing a front door in January is a safety protocol? Sterling sighed, adjusting his expensive French cuffs as if he were being forced to explain basic arithmetic to a child. Your Honor, these old buildings are massive liabilities. We were doing mandatory structural assessments. The door was warped. The contractors removed it to measure for a replacement. If the tenant was inconvenienced, it's unfortunate, but progress is messy. We offered him a buyout months ago to move somewhere more suitable for his income bracket. He stubbornly refused. He didn't just admit to the harassment. He tried to rebrand it as a favor. He was utilizing the classic playbook of the untouchable elite, making the victim sound unreasonable for simply wanting to exist in a space they had rightfully paid for. So, let me ensure I understand your business model, I said, leaning forward. You buy a building, you decide a rent-controlled tenant is financially inconvenient, and you authorize your contractors to strip his door off its hinges to freeze him out, hoping he will simply give up and leave? I never explicitly authorized the door removal, Sterling countered smoothly, flashing a patronizing smile. I delegate. I oversee a multi-million-dollar portfolio. I don't micromanage carpenters. If they made an error in judgment, take it up with them. It was the ultimate coward's defense. The man who claimed he made the rules just 2 minutes prior was now hiding behind anonymous laborers. The second accountability was demanded. But paper trails do not lie, and Elias Thorne was not as helpless as his landlord had assumed. I removed my reading glasses and placed them carefully on the polished wood of the bench. The gallery, which had been murmuring softly during Sterling's testimony, went completely silent. They could feel the shift in the room's atmospheric pressure. Let's examine this delegation, Mr. Sterling, I said, picking up the stack of photographs Elias Thorne had provided. I held up the first image so the defense table could clearly see it. This is a photograph of Mr. Thorne's front door, or rather, the empty space where his front door used to be. I held up a second photograph. This is a picture of his personal belongings, including a shattered antique display case dumped into a public hallway like garbage. I picked up a third document. And this is a sworn affidavit from the maintenance foreman, Mr. Davis, stating that he received direct, written instructions from your personal assistant to remove all barriers to Unit 4B immediately, regardless of occupancy status. Tell me, Mr. Sterling, does your assistant often issue aggressive demolition orders without your explicit approval? Sterling's attorney, a man whose hourly rate probably exceeded Elias Thorne's annual pension, stood up quickly. Your Honor, my client oversees a massive operation. The phrasing in that email was misinterpreted by the ground crew. It was a miscommunication regarding the vacant Unit 4A, not 4B. A miscommunication, I repeated flatly. Mr. Counselor, if I ask a contractor to fix my plumbing and he accidentally bulldozes my neighbor's living room, that is a miscommunication. When a crew specifically targets a rent-controlled tenant's apartment, removes the door in freezing temperatures, and dumps a 7-1-year-old man's belongings into the hall, that is a strategy. A very cruel, very deliberate strategy. I looked past the lawyer and fixed my gaze entirely on Arthur Sterling. He was no longer smirking, though his posture remained rigidly arrogant. He still believed he could talk his way out of this. He believed that if he threw enough expensive legal jargon at the problem, the reality of what he had done would magically blur. Mr. Thorne, I addressed the plaintiff gently. How long were you without a door? Elias's voice wavered slightly, the memory clearly bringing back the sharp sting of that January night. 4 days, Your Honor. I nailed a heavy tarp across the frame, but the wind tore right through it. I couldn't leave to buy groceries because I was terrified someone would steal what little I had left. I called the police on the 3rd day. When the officers arrived, the building manager told them I was a squatter, refusing to leave a condemned unit. The audacity of it was staggering. It wasn't enough to freeze him out. They had actively tried to weaponize the police against a terrified old man. I turned back to Sterling. Did you instruct your building manager to file a false police report classifying a legitimate, rent-paying tenant as a squatter? Sterling shifted in his seat. The tailored suit suddenly looked a little tight across his shoulders. I don't handle low-level security disputes, Your Honor. If the manager felt threatened by Miss Thorne's refusal to cooperate with our renovation schedule, He acted within his rights to involve law enforcement. Threatened? I asked, my voice rising just enough to let the genuine outrage bleed through. You are telling this court that your property manager felt threatened by a 7-1-year-old retired schoolteacher whose door had just been ripped off? A man who was sleeping in his winter coat because your company decided heat was a luxury he no longer deserved? The defense attorney tried to intervene again. Your Honor, we are prepared to offer a settlement for the damaged display case and any incidental discomfort. We can write a check today to resolve this matter. You don't get to buy your way out of cruelty, counselor, I snapped. This isn't a broken toaster. This is a man's home. Arthur Sterling's face flushed a deep, uncomfortable red. It was the color of a man who was used to giving orders, not explaining them. He looked down at the defense table, perhaps realizing for the first time that the walls of a courtroom are not insulated with the same soundproofing as a corporate penthouse. Your Honor, Sterling's attorney interjected, his voice losing some of its polished sheen. We acknowledge the hardship Mr. Thorne endured. It was a failure of protocol, not a malicious act. We are prepared to compensate him for the damaged property and the cost of alternative lodging during the structural assessment. And what is the value of a man's peace of mind in his own home? I asked, looking directly at Sterling. Is there a line item in your corporate budget for terrifying a 71-year-old man? Sterling finally broke his silence. I am a businessman, Judge. I deal in properties, not emotions. The building was operating at a loss because of rent-controlled units like his. I have a fiduciary duty to my investors to maximize the value of that asset. We offered him a generous buyout. He was the one who decided to be stubborn. There it was. The absolute, unvarnished truth. The logic of a man who calculates human worth purely in terms of profit margins. He didn't just lack empathy. He saw it as an operational inefficiency. I leaned forward, my voice dropping to a near whisper. Mr. Sterling, you do not have a fiduciary duty to break the law. You do not have a fiduciary duty to orchestrate the illegal eviction of a tenant. And you certainly do not have a fiduciary duty to strip the dignity from an elderly man by leaving him shivering in a doorless apartment. I picked up another document from Mr. Thorne's file. This is a record of Mr. Thorne's hospital visit 3 days after the door was removed. He was treated for early stages of hypothermia and severe stress-induced hypertension. Do you think a check for a broken glass cabinet covers the cost of nearly freezing a man to death? Sterling scoffed softly. People get cold in winter, Your Honor. It's New York. You can't pin a hospital visit on a drafty hallway. The gallery gasped audibly. Even his own attorney looked at him with a mixture of disbelief and panic. Arrogance is a dangerous thing, but arrogance paired with absolute blindness to reality is a fatal combination in my courtroom. A drafty hallway? I repeated. Mr. Sterling, you removed the door. You created the draft, you created the danger, and you did it intentionally. I turned to Elias Thorne. Mr. Thorne, what exactly are you seeking from this court today? Elias stood up slowly. He didn't look at Sterling. He looked only at me. I don't want his money, Your Honor. Not a single cent of it. I want to go back to my home. I want my door replaced. And I want him to stop trying to erase me just because he thinks I don't matter. That statement was the crux of the entire case. It wasn't about the physical damage. It was about the erasure of a human being for the sake of corporate convenience. I looked back at Arthur Sterling. The man who had walked in believing he owned the room was now staring at a reality he could not purchase his way out of. Mr. Sterling, I began, my voice ringing clear and authoritative across the courtroom. You walked in here today claiming that you make the rules because you own the building. Let me clarify something for you. You may own the bricks, the mortar, and the title, but you do not own the law. And in this room, I make the rules. I didn't just rule in favor of Elias Thorne. I ordered Sterling Global Holdings to immediately restore the apartment, replace the door, and cease all harassment. I awarded substantial punitive damages not just for the physical destruction, but for the intentional infliction of emotional distress and the blatant violation of tenant rights. But the judgment didn't stop there. I ordered the transcript of the hearing, along with the photographic evidence and the foreman's affidavit, to be forwarded directly to the city's housing authority and the district attorney's office for investigation into illegal eviction practices and criminal harassment. Arthur Sterling's empire of intimidation had just met the one force it could not buy: absolute, unflinching accountability. The moment I mentioned the district attorney and the housing authority, the atmosphere at the defense table shifted from irritation to genuine panic. Arthur Sterling's custom suit suddenly seemed to weigh him down. He stood up abruptly, completely abandoning the relaxed, arrogant posture that had defined his entrance into my courtroom. "Your Honor, wait. Let's not escalate this into a bureaucratic circus," Sterling said, a sharp edge of desperation cutting through his previously polished tone. "An investigation is completely unnecessary. We are willing to reach a highly favorable confidential settlement with Mr. Thorne right now. We will triple the requested damages. We will relocate him to a luxury unit, rent-free, for an entire year." I looked at him in silence. It is a fascinating psychological study to watch someone who believes money is the ultimate skeleton key suddenly realize they have encountered a door it cannot unlock. "A confidential settlement?" I asked, my voice echoing in the quiet room. "Mr. Sterling, you are no longer negotiating a real estate transaction. You are answering for the systemic abuse of an elderly citizen. You do not get to purchase silence when your actions represent a clear threat to public safety and basic human rights. My ruling stands, and the referrals have already been recorded." His attorney grabbed his arm, pulling him back down into his seat and whispering furiously into his ear. The attorney knew what Sterling was only just beginning to understand. An investigation by the city's housing authority into a landlord known for aggressively flipping rent-controlled buildings meant a full, uncompromising audit. It meant opening the books. Every ignored complaint, every intentional miscommunication, and every forced eviction across his entire real estate portfolio was about to be scrutinized under a legal microscope. The legal and financial walls he had built around his empire, constructed with intimidation and endless resources, were crumbling in real time. Had he simply apologized, replaced the door, and treated Elias Thorne with a shred of decency, this would have remained a minor civil dispute. Instead, his desperate need to assert absolute dominance had just handed the city the exact documented evidence it needed to dismantle his predatory business model. I turned my attention away from the defense table. They no longer mattered. The machinery of justice was already in motion. I looked down at Elias Thorne. He was still standing at the plaintiff's podium. He hadn't cheered. He didn't gloat or point fingers at the man who had tormented him. He simply took a deep, shaky breath, as if his lungs were finally drawing in warm air after days of freezing cold. His hands, previously trembling with anxiety, were now steady as he carefully gathered his photographs, placing them neatly back into his worn folder. "Thank you, Your Honor," he said softly. It was not a theatrical display. It was just a quiet, dignified gratitude from a man who was thankful for being seen, heard, and protected by the system when he was at his most vulnerable. Months later, the ripple effects of that single hearing were still expanding. The judgment against Arthur Sterling was never just about replacing a door or paying a fine. It was about documentation. The transcript of our proceedings, the foreman's affidavit, and the photographs of Elias Thorne's ruined apartment became the foundational evidence for a much larger investigation. When the housing authority and the district attorney's office began to dig, they found exactly what I suspected they would find. Sterling Global Holdings didn't just have a few aggressive contractors, they had an institutionalized strategy of intimidation. The audit revealed a pattern of manufactured maintenance emergencies across 15 different rent-controlled buildings, heat shutoffs during winter, prolonged elevator repairs in buildings housing elderly tenants, and aggressive buyout offers disguised as safety warnings. Arthur Sterling had built a highly profitable machine that functioned precisely by exploiting the vulnerability of people who could not afford high-priced attorneys to fight back. But the most devastating blow to Sterling was financial journalists caught wind of the investigation. Investors, who had previously praised Sterling's high returns without asking too many questions about his methods, suddenly found themselves associated with headlines about freezing out 7 one-year-old widowers. Money is cowardly. The moment his reputation shifted from shrewd businessman to predatory slumlord, his major credit facilities began to pull back. Development projects stalled. The empire that he claimed allowed him to make the rules was collapsing, not because he ran out of money, but because the darkness his operations required had been suddenly and brutally illuminated. Meanwhile, Elias Thorne's life returned to a quiet rhythm, though he had inadvertently become a symbol for tenant rights in the city. Former colleagues reached out. Legal aid clinics asked him to share his story. He disliked the attention, preferring the quiet solitude of his books and his routines. But one detail stood out. About a year after the trial, I received a brief, handwritten note from him. It was simple and unadorned. "Your Honor, the heat has worked perfectly all winter, and the new door is much heavier than the old one. Thank you for reminding them that I live here. That sentence, "Thank you for reminding them that I live here," encapsulated the entire purpose of the courtroom. It is very easy for the powerful to view the vulnerable as abstractions, as line items on a spreadsheet, or as obstacles to be removed. The law exists to interrupt that abstraction. It exists to insist, loudly and officially, that every person has a name, a history, and the absolute right to dignity. Arthur Sterling thought he was untethered from consequence because his wealth had always shielded him. He walked into my courtroom believing that reality would simply bend around his checkbook. Instead, he met a reality that could not be bought. If there is a lesson to be drawn from the collapse of Sterling Global Holdings, it is not simply that a wealthy man fell from grace. The lesson is that arrogance is an incredibly fragile foundation for an empire. When you build your success on the assumption that other people do not matter, you leave yourself entirely defenseless the moment someone with the authority to stop you finally asks for the evidence. Never mistake a bespoke suit for actual power. And never assume that because you hold the deed to a building, you own the right to strip a man of his dignity. The rules are not made in the penthouse. They are made and enforced in the courtroom. The true measure of a man is not how he acts when he holds all the power, but how he unravels the moment he loses it. For Arthur Sterling, the unraveling was spectacular and entirely of his own making. A few months after my ruling, the district attorney's office officially indicted Sterling on multiple felony charges, including reckless endangerment, criminal harassment, and fraud. The civil penalties and punitive damages I had imposed in my courtroom were merely the spark. The criminal investigation was the wildfire that burned his real estate empire to the ground. I read about his arraignment in the morning papers. The man who had once stood in my courtroom, adjusting his French cuffs and claiming he made the rules, was now forced to surrender his passport and post a multi-million-dollar bail just to sleep in his own bed. According to the reports, when the judge in the criminal court denied his request for special accommodations, Sterling threw a tantrum, demanding to speak to the mayor. It is a pathetic sight to witness a grown man realize that his golden ticket has suddenly expired. What fascinated me most, however, was not his legal peril, but his social exile. The wealthy elite, the board members, the investors, the politicians whose campaigns he had funded abandoned him overnight. People of his status can tolerate ruthlessness, and they will often turn a blind eye to greed, provided it is kept quiet and elegant. But they absolutely despise bad press and exposure. By speaking his arrogance aloud on the public record, by making his cruelty impossible to ignore, Sterling had become a toxic liability. His former allies didn't suddenly grow a conscience. They simply recognized that standing next to him was no longer profitable. That is the ultimate tragedy of building an empire on fear and transactional relationships. The moment you can no longer write the checks, you cease to exist in their world. In stark contrast, the people he had spent years erasing were finally becoming visible. Following the exposure of Sterling's tactics against Elias Thorne, a floodgate opened. Dozens of other tenants from across his properties came forward with their own stories of manufactured maintenance crises, frozen apartments, and illegal lockouts. They banded together and formed a massive class action lawsuit. These were working-class people, nurses, transit workers, retired teachers who had previously felt entirely powerless against a billionaire landlord. They had believed the lie that Sterling wanted them to believe, that wealth equals authority and fighting back is useless. But Elias Thorne's courage in my courtroom had shattered that illusion. Once one person proves that the giant can be brought to his knees, the rest of the village quickly loses its fear. This is why the courtroom remains one of the most vital institutions in our society. It is the ultimate equalizer. Outside these walls, money can buy almost anything: access, comfort, silence, and obedience. But inside a functioning courtroom, a handwritten rent receipt from a 7-1-year-old widower carries the exact same weight as a corporate ledger. Truth does not recognize tax brackets, and justice does not bow to a bank balance. Arthur Sterling learned that lesson too late. He spent his life believing that the world was his personal chessboard, and the people on it were merely pawns to be sacrificed for his convenience. He forgot that even the most powerful king can be cornered by a single, unyielding move. Years after the gavel fell, the name Arthur Sterling became a cautionary tale in corporate boardrooms. He didn't go to prison for life. Men with offshore resources rarely do, but he was forced into a humiliating plea agreement that stripped him of his real estate license permanently. He was legally barred from managing, owning, or operating residential properties in the state of New York. The empire he had built on the frozen, doorless apartments of the vulnerable was auctioned off piece by piece to settle his mounting civil and criminal liabilities. The building where Elias Thorne lived was purchased by a nonprofit housing cooperative. For the first time in decades, the tenants were not treated as liabilities on a spreadsheet, but as human beings. The heat remained on. The doors remained firmly on their hinges. Elias lived out the rest of his days in that same apartment. He didn't become a wealthy man from the settlement. He used the majority of the punitive damages to establish a small legal defense fund for elderly tenants facing unlawful evictions. He called it the Sanctuary Fund. It was his way of ensuring that no one else would ever have to sit in the freezing cold, guarding their memories, simply because a billionaire wanted a higher profit margin. People often ask me if cases like this make me cynical. They assume that seeing the sheer greed of men like Arthur Sterling day after day must erode my faith in society. But it does the exact opposite. Sterling's arrogance was loud, flashy, and ultimately fragile. Elias Thorne's dignity was quiet, enduring, and made of steel. When the two collided in my courtroom, the steel shattered the glass. This is the absolute purpose of the justice system. It is not a flawless machine, but when it operates correctly, it is the one place on earth where the illusion of elite invincibility goes to die. A courtroom does not care about the brand of your watch, the location of your penthouse, or the size of your bank account. It cares about evidence. It cares about truth. Arthur Sterling walked up to my bench and proudly declared, "I make the rules here." He was so blinded by his own privilege that he couldn't see the reality of the room he was standing in. He forgot that a society cannot function if the wealthy are allowed to write their own laws. If you ever find yourself in a position of power, remember the spectacular collapse of Sterling Global Holdings. Remember that no amount of money can buy back your reputation once your cruelty is entered into the public record. You do not make the rules. The law makes the rules. And the bill for your arrogance will always, eventually, come due.